kind enough. Why don't we face?
Okay. We'll be back here.
For press people, I have resumes and the statements of testimony that the four witnesses were going to give. Okay? Now, just a second.
Where do you want us?
Up against the wall.
Up against the wall.
After you.
The purpose of this conference is to give each of the expert witnesses a moment to give their testimony to the public. We'll begin with Robert Jay Lifton, who is a psychiatrist from Yale.
Had I testified, I would have described my findings in Hiroshima in a study I made in 1962, living and working there for 6 months, about the lifelong encounter with death experienced by survivors from a moment of immersion, a moment of being exposed to the first atomic bomb dropped on a human population. I would have testified to the 4 stages of their experience: the time the bomb fell, the outbreak of symptoms, often fatal, of acute irradiation, and the discovery afterwards of chronic radiation symptoms, increase in leukemia and cancer, and finally a kind of lifelong sense of being victims of the first atomic bomb, and also a population discriminated against as victims subsequently in their life in Japan. I would have talked about the problem of psychic numbing, which I encountered, that is, psychic numbing, a diminished capacity to feel, which I encountered first in Hiroshima survivors, but then began to think about in terms of those who make or project using nuclear weapons, and indeed in all of us, because of the very difficulty of taking in, of absorbing what weapons do. The essence of psychic numbing, and psychic numbing is at the heart of this case in my view, is the inability to feel what happens at the other end of the weapons. Therefore, when people talk about nuclear scenarios or nuclear stockpiles or indeed nose cones, instead of talking about bombs that kill and maim millions of individuals, that's an example of psychic numbing by use of language. I would have talked about the extent of psychic numbing in our society and the struggle to develop some kind of awareness of the true danger of nuclear weapons. It's a constant, very difficult struggle because of all the psychological and social forces that reinforce numbing. And one could see the actions of the defendants of this case as an effort to break through the psychic numbing and increase and extend awareness of the true danger of nuclear weapons. And finally, I would have talked about a summary sense of what would happen to people, potential survivors, if there were any, of a nuclear war, pointing out that the present bombs are 100 to 1,000 times the size of the baby Hiroshima bomb, and also that we can expect no outside world to come in and rebuild a city that's been bombed, as one had in Hiroshima, which was the only reason why Hiroshima could be rebuilt. And finally, that when people talk about what it would be like to survive a nuclear war, for those few survivors, if any, and they say, as a number of world leaders have said, the survivors would envy the dead, even that doesn't go far enough. I would go further and say that the survivors would feel themselves as if dead. The survivors would not really feel alive. They would be essentially immobilized, stunned, living less than a half-life. In other words, there is no psychological capacity to prepare for or survive nuclear war.
Thank you. We'll stop for questions, and we'll stop for questions after each one of the witnesses has been given a chance to speak.
What's your reaction?
Okay,
you're going to take every one.
We're going to take all 4 of them first. Yeah. This is Professor Richard Falk from Princeton. He's an expert in international law.
I would have testified as to the relevance of international law to the defense that these 8 individuals are trying to make in the court, particularly the essence of their beliefs that led them to do what they did was the feeling that the kind of nuclear weapons and the kinds of nuclear policies that the United States government is currently pursuing violate international law and violate the kinds of principles that were established at the Nuremberg judgment by which individuals are responsible for their acts in relation to international law. This, in my judgment, goes to the essence of a fair legal trial in this case, because their criminal intent depends, it seems to me, on the kind of attitude they possessed toward the acts they undertook. It is, by weight of authority in international law, reasonable to believe, even if some disagree, that the use of nuclear weapons in any form in the course of an international conflict would constitute a crime against humanity. This has been established by resolution of the United Nations. It has been established by the Shimoda decision, a Japanese court decision that examined the bombing of Hiroshima and Nagasaki. It has been agreed to by international lawyers from several different legal systems in the world. Therefore, it is not a crazy idea to suppose, first, that international law precludes the reliance on these kinds of nuclear weapons, and secondly, that individuals have an obligation that's higher than obedience to domestic law to prevent the commission of these severe crimes of state. President Franklin Roosevelt during World War II urged the people of Germany to act in violation of German law to prevent the war crimes being committed by the Nazi leadership. Nothing less than this, it seems to me, is at stake here, where individual citizens are undertaking at great personal risk and on the basis of the most serious reflection an attempt to enforce law of the highest sort that bears directly on the destiny of our country and on, indeed, the peace of the world as a whole. Finally, I would have tried to say that it's well established as a matter of law in the United States that international law is relevant in domestic courts. The Supreme Court has said on numerous occasions that international law should be applied by courts in this country whenever it's relevant, and indeed by the Constitution it's part of the supreme law of the land, and therefore to exclude it from even being heard in a court seems to me to go to the essence of what a fair trial would mean in a case of this sort.